Good. Good afternoon, everyone, and I apologize that we're getting started a few minutes late, but I want to remind you that this will be available. If you have to leave early, we will send you the link so that you can access it. So welcome, everyone, and thank you for joining us for today's presentation. We have almost 100 HR professionals from a vast range of industries. My name is Patricia Reilly, and with me is Sal Gangemi. I am the chair of Murtha and Cullina's Labor and Employment Group, and today we'll be talking to you about managing marijuana in 3 different states, which have 3 different laws, regulations, and actually more in New York, as Sal will tell you. First, I'm going to take a moment to go over a couple of housekeeping items. All callers are currently in listen-only mode. If you have questions during the presentation, you can write them, but I'm going to tell you that this is very dense material, and I do not expect that we are going to have time for questions at the end. So my advice on that is if you have questions, you can contact Sal or me directly by email after the seminar, and we will address them. But I think today there may not be sufficient time. This webinar, as I said, is being recorded, and the participants will receive an email following today's presentation with the PowerPoint slides and a link to the webinar recording and an attendance certificate. So let's begin. This is Managing Marijuana, what Connecticut, New York, and Massachusetts employers need to know. Today's goal: many states have legalized the use of marijuana for medical purposes, and some have legalized its recreational use. What does this mean for employers? Can you fire someone for using medical marijuana? Can you refuse to hire a job applicant who uses medical marijuana? What are the employer's obligations to provide a reasonable accommodation to a medical marijuana user? I will tell you, these are extremely hard issues. It usually involves a lot of back and forth with the employer to discuss it with the applicant or employee. And while we're going to give you some general guidelines here today and outline the law, often these are very difficult, very fact-based decisions. So 33 states plus the District of Columbia permit the use of medical marijuana. And as you can see, this is the list, and this list does continue to evolve. This is the current list. I'm not going to read all of the states, but as you can see, medical marijuana is, of course, permitted in Connecticut, permitted in Massachusetts, permitted in New York, the 3 states that we are focused on today. So now we'll first start with medical marijuana.
Okay, so thanks, Trish. So as you can see, well, we have Cheech and Chong there to demonstrate to us that there are 10 states, including the District of Columbia, that permit the use of recreational marijuana. Okay, and Colorado, having been one of the first, is on that list, and we also have Massachusetts on that list. So part of our talk today, although we are focusing mainly on medical marijuana, we cannot ignore the prospect of recreational marijuana becoming legal in the near future. In addition, 24 states, including the District of Columbia, have decriminalized marijuana. Now, not all of them have decriminalized it in the same way. For example, some of the states with the 2 asterisks, they've partially decriminalized certain marijuana possession offenses, although the law still classifies marijuana possession offenses as criminal. There is no jail time associated with that. Hawaii's law takes effect in January of 2020. So as you can see, these lists are in fact evolving going forward. Now, let's look at federal law. It's okay. Federal law. This is an interesting concept because marijuana under federal law is still classified as a Schedule I drug. Okay, which basically means that the drug or whatever substance you're talking about has a high potential for abuse, okay? The drug has currently no accepted medical use in treatment in the US, and there's a lack of accepted safety for the use of the drug or other substance under medical supervision. One point I want to make about this is that about 3 weeks ago, a bill started making its way through Congress through the Judiciary Committee to remove marijuana from the list of Schedule I drugs. So that's a huge step in terms of alleviating some of the tensions between state law and federal law that cause a lot of our problems in determining how we deal with these issues.
So what are the legal issues for employers? There is the question of whether the Americans with Disabilities Act would apply, and while the federal Disability Act might not apply, the corresponding state and local laws may, and we'll talk about that in these jurisdictions. Does the Family and Medical Leave Act apply? It may very well, depending on the circumstances. The employer has a duty to provide a safe workplace under OSHA, but that does not preclude the use of medical marijuana in the workplace. And as Sal just mentioned, there is tension between state and federal law on the medical marijuana and, of course, the recreational marijuana use, because it is still classified under federal law as a Schedule I narcotic or drug, excuse me. So let's start with the Americans with Disabilities Act. As we know, individuals currently engaging in the illegal use of drugs, which includes Schedule I marijuana, are not protected. So under the Americans with Disabilities Act, the federal law, they are not protected. And employers may adopt reasonable policies and procedures to ensure that employers are not engaging in the illegal use of drugs. Again, we caution, this is federal law, which conflicts with state law on these topics. However, is there any coverage for a medical marijuana user under the ADA? Well, former or recovering addicts must be accommodated under the ADA, and these individuals must be engaged in the interactive process. So drug addicts may suffer from a disability under the ADA, provided that they are not currently using drugs and marijuana. My view on this is that it's highly unlikely that you're going to get somebody who says, I'm an addict to marijuana addict, and therefore need accommodation under the ADA. Particularly in jurisdictions where recreational use is already permitted anyway. And with regard to current use, this is not covered under the ADA.
Okay, so under the ADA, we have to accommodate employees with a disability, and we focus when you're dealing with the ADA, you don't necessarily focus on their status as a medical marijuana user or as a certified medical marijuana user. You focus on the underlying disability, okay? It's the underlying disability that counts under the ADA. And you'll see when we talk about Connecticut and New York and Massachusetts that that's not entirely the case there. But under the ADA, it's all about the underlying disability. It's still important to engage in the interactive process for purposes of determining whether there is a reasonable accommodation that could allow the employee to continue to work. And this is something that the EEOC has said, that you can look to see if there are alternative medicines or therapies that could also alleviate symptoms. This is something that the EEOC has mentioned in comments. I would be very careful about trying to suggest alternative medications or alternative treatments to employees, but that doesn't mean it's completely off the table. It is something that needs to be, it is something that you can certainly consider. And there are risks with accommodating or not accommodating employees. I mean, let's face it, if you're going to accommodate an employee under these circumstances, if they're impaired, it could potentially compromise safety. It could end up causing liability to third parties. You could end up dealing with police or law enforcement. not accommodating them could result in a discrimination lawsuit, and the loss of otherwise, an otherwise qualified and good employee. And there's always the bad press issue that you need to take into account.
So the Family and Medical Leave Act, as we know, covers treatment for substance abuse, including marijuana abuse. So marijuana abuse may be considered a serious health condition under the FMLA, provided that conditions for inpatient care and/or continuing treatment are met. I will tell you, I have not encountered this as an issue in my practice. Sal, have you ever encountered this?
No, I have not. And what's interesting is I think part of it is that, and maybe part of it is that employees are sometimes reluctant, like you said earlier, to just come forward and admit that there's a problem and that they're going to need time off for the treatment of that substance abuse.
Right. So I will say I've encountered it for other substances, not for marijuana.
Oh, not for marijuana.
And so I've definitely encountered it for other substances. I think the issue for me is I've not seen it for marijuana because most people don't consider their marijuana use to be an addiction. It's either medical marijuana or recreational use allowed under the law. So as we said previously, OSHA does have a duty to provide a safe workplace, but despite the general duty, it does not require or authorize drug testing, nor does it require employers in states where medical marijuana is allowed to ban medical marijuana use in the workplace.
Okay, so here are some things you can do when there's a safety concern or when you're dealing with safety sensitive positions in terms of drug testing. And we are going to talk a little bit about drug testing because these issues are so intertwined. Try to institute a policy that requires employees to disclose the use of medications that could potentially impair their ability to work, if the request is job related and consistent with business necessity. So what types of positions are those? Well, we're talking about construction, in the construction industry, drivers, teachers, law enforcement. These are safety sensitive positions. And under those circumstances, it makes sense to institute a drug testing policy that checks to make sure that they're not suffering from any impairment. Obviously, it has to be done in compliance with the ADA. If an employee does test positive for marijuana, confirm that the employee is prescribed marijuana. Okay, in those states where recreational marijuana is not yet legal. So.
And I want to just underscore here that drug testing policies, as we'll get into later in the presentation, are also state specific. So we know that Connecticut does not allow for random drug testing of a urinalysis sort, for example. We'll get into that in detail. This is starting with the federal law, and the next slide is, as we see, shows that federal and state law, there is some huge difference. And with regard to medical marijuana, there's this conflict between federal and state law. There can be conflict with regard to drug testing, and it's very difficult to administer. That is why you have to really look at the state law. So let's start with Connecticut. For those of you in Connecticut, you know that Connecticut offers medical marijuana registration identification cards for patients with debilitating medical conditions. There's no arrest, prosecution, or penalty, including professional licensing penalties, for the palliative use of marijuana that is consistent with state law, and violation of the anti-discrimination provision allows a user to sue in court. Okay. So employers generally are authorized to prohibit the use of intoxicating substances during work hours. I will tell you, this is extremely difficult to manage because studies show that marijuana can be in the system for up to 12 hours. So this has been read narrowly in Connecticut to mean you can't take it while you're on, while you're working. You can't take the substance while you're working. I don't think that under the current evidence-based documentation that I've read, that there's any way to rule out that someone is marijuana free because it stays in the system for such a long time. Okay, so we go to the second bullet point, which is that although palliative use is permitted, it is not permitted in the workplace. So the prohibition on employment discrimination based on the qualifying patient status is waived. I'm sorry, I'm not reading
it's waived
properly.
Yeah.
If declining to follow what is required. Okay, so what this means, it's waived if declining to follow what is required by law, federal law. So this is also something that needs to be administered very carefully, because even certain organizations that may receive federal funding, that does not necessarily mean that you can discriminate against palliative use medical marijuana patients. So what I'm learning is that the only really clear-cut way to ensure that you can rule out a medical marijuana user is if you have to comply with federal Department of Transportation rules. Those are pretty clear-cut. You cannot be on medical marijuana or other kinds of drugs, and you are required to undergo drug testing. Those of you who may be subject to DOT rules would know this, but I know many of the participants here on this webinar their organizations may receive federal funding. That is not going to be sufficient in and of itself to say, therefore, we can discriminate against medical marijuana users, okay? So employers cannot use the federal law exemption as a reason to discriminate against a qualifying patient in the absence of an actual federal requirement. So you might have a contract that says, we're giving you this money contingent on no medical marijuana users, but it has to be very clear that it is absolutely required by the receipt of federal funding, and not just general receipt of federal funding. And the courts have upheld this.
Right, and it needs to be an express federal requirement. It can't just be this general policy that federal law doesn't consider marijuana to be a legal substance.
So here's the state statute, which has been interpreted by a case that we'll talk about shortly. But the statute itself says, unless required by federal law or required to obtain federal funding, no employer may refuse to hire a person or may discharge, penalize, or threaten an employee solely on the basis of such person's or employee's status as a qualifying patient or primary caregiver under the statutory sections. Now, when we first read this statute, before there was any case law interpreting it, we thought on its face meant if an employer received federal funding, required to obtain federal funding, that would allow them not to hire medical marijuana users. But to underscore Sal's point, that is not the law. It has to be an explicit contractual arrangement stating that you can't use it. Sometimes it may be, a statutory scheme like under the Department of Transportation rules, but you have to be able to point to specific, not a specific rule, not just a general federal funding situation. Okay. However, as we said, the ingestion of marijuana in the workplace is not protected. And this is important for those of you in these kinds of organizations. Protections do not apply to the ingestion of marijuana in a motor bus or a school bus or in any other moving vehicle, in the workplace, on any school grounds or any public or private school, dormitory, college, or university property, in any public place, or in the presence of a person under the age of 18. Okay, presence means within the direct line of sight of the palliative use of marijuana or exposure to secondhand marijuana smoke or both. But I mean, the thing about this particular protection is that this one is a little tricky because this is not really necessarily employee. So this really is just people, right? So it's not protected if you're taking medical marijuana on a motor, on a bus or on school grounds, that kind of thing. So this is really just a more general prohibition with regard to these places. So covered conditions are evolving. So the list first started, it's published on the Department of Health website, and the debilitating medical conditions started out with these various things, and a doctor can petition to have a condition added. So, cancer and glaucoma were really two of the very driving forces, and also HIV and AIDS, and Parkinson's to some extent, epilepsy. These were some of the very serious health conditions that really drove the legislation behind the use of medical marijuana, because people were finding that these things could help significantly with treatment of these serious medical conditions. They could help with pain, and in some cases with epilepsy, for example, they could help even decrease the number of epileptic events. And so some of these were originally on the website: multiple sclerosis, spinal cord damage, Crohn's disease. PTSD has been one of the few mental health conditions that is actually on the website. And so I don't know if they've updated it, Sal. Have you seen any?
No, I haven't, and I was curious because that did catch my eye. Obviously, that it was the only mental health condition on there, but you also have anxiety disorder and other conditions that apparently tend to be treated, or at least people claim can be treated by marijuana.
But those are not covered conditions under Connecticut state law currently, and therefore the interesting thing about that is really more from a prescriber point of view. The prescriber should not be giving somebody medical marijuana if their only diagnosis is depression or anxiety, for example. They have to be diagnosed according to the provider with PTSD for it to be a legitimate covered condition, such that they would obtain a medical marijuana card and get medical marijuana. So here are some more types of diseases. This is interesting. Severe psoriasis. I think that might be one of the newer ones. ALS, colitis, complex regional pain syndrome. So
does that mean you're not happy about where you live?
Regional pain, yeah. I think it means that they don't know, necessarily the source. That's a really catch-all condition, right?
And the post-laminectomy syndrome is essentially if you've had back surgery and it hasn't done anything to alleviate your pain. It's really interesting because that's also sort of I don't want to say it's a catch-all, but it's very subjective in terms of, when someone has sickle cell disease, or ALS or colitis. But so these are things that, these are sort of grayish areas.
The other thing I'm going to say that's not addressed in the medical marijuana literature is that, my understanding as a non-physician, non-medical provider is, that CBD is what is the component of medical marijuana that helps with pain. And a lot of these symptoms that are being treated here with these kinds of illnesses would be pain related. And so if CBD is not that it's a pain related component, but it does not produce the high, that it's the THC, which can impair people's functioning. The law doesn't go into having a discussion about what type of medical marijuana is being prescribed and what percentage is CBD versus THC. And we know too that CBD products are generally available in the workplace. I also don't know, CBD products are generally available in the marketplace, and people could be using these without a prescription, but from what I'm reading, those do not produce the high. And so the question is, you know, in Connecticut, if you're hiring somebody who has a medical marijuana card, how far can you go in questioning what type of medical marijuana they're on? What's the percentage of CBD versus THC? Is it a pure CBD product? And would that make a difference for certain kinds of conditions? You know, in Connecticut, this is an evolving law, and it's very unclear, you know, how far you can push it. And if you can ask, you know, well, what's the percentage of THC versus CBD? Because THC, when I was talking earlier about remaining in your system, my understanding is that's the component that can remain in your system for a very long time. So as usual with these newer statutes, you know, it's evolving, and what degree of discussion you can have with an applicant's, for example, physician to talk about, you know, whether they can do a job, it's very unclear, and there isn't really a lot of case law. There's one case so far in Connecticut that has addressed this issue at all.
Right. You absolutely need to be careful when dealing with the issue that Tricia was just discussing, because we still don't know what the parameters are. We still don't know how much we could get into. So it's very important that you consider each instance as its own, you know, case, because everything is decided on a case-by-case basis.
So as I just mentioned, we have one case, one published decision called Nofsinger versus SSC Niantic Operating Company, doing business as Brook Nursing and Rehabilitation Center. So this was a long-term care nursing and rehab facility. This organization relied on the various reasons for why it said it could not hire a person on medical marijuana. The primary thing here is it did rely on federal law because it was a recipient of federal funds. So it said, for example, that the Controlled Substances Act under federal law prohibited it from hiring anybody on medical. The court, in a very detailed analysis, said that the federal statutes do not prohibit employers from hiring applicants that may be using illegal drugs outside of the workplace. This, frankly, this decision was fairly shocking to some of us in, you know, the employment field, because we thought the court, I still think the court went far in saying, you know, that the statute which says federal funding doesn't really mean federal funding under Connecticut law. It means specific prohibition in the kind of federal funding that you're getting. And so the other thing that Nofsinger established, which we did anticipate, is that there is a private right of action against the employer under this statute. There was some discussion about, well, the statute says you can't discriminate, but it doesn't really talk about an employee being able to sue the employer. I always thought the statute meant the employee can sue the employer, and Nofsinger established that. But the part of the decision that made it really complicated for employers who may have positions in which they don't want people to be using medical marijuana because they are receiving federal funding, that is not sufficient. You still have to look at the particular job and enter into an interactive process to see if the person's going to be able to do the job with the medication. Well, it's really, as Sal said, to do the job with the disability. So you're really focused in the interactive process, you know, more on the disability and the use of the medical marijuana as a treatment for the disability. So while we were talking earlier about the ADA, under which does not require accommodation for medical marijuana use, state law in Connecticut requires the employer to accommodate disabled individuals using medical marijuana. But what does accommodate mean? This is where Sal was saying it's a very fact-based analysis. What's the job, and can the person perform the essential functions of the job with medical marijuana? I do not advise getting into this with jobs that are not difficult. They're run-of-the-mill, kinds of jobs where people can likely perform the essential functions of the job while on medical marijuana. I don't really think that there's much dispute about that. So, if you're working in an office and you're doing office type jobs, and by the way, Singer, I believe that was a CNA position. So that, one could argue, why should a CNA be on medical marijuana? Well, in that case, it was a CNA on medical marijuana. But then to me, the really sticky questions are the safety sensitive positions. Those are the hard ones to deal with, and you have to deal with it on a case by case basis. And if you have concerns about a person who has tested positive for medical marijuana, can that person perform the essential functions of the job if it's a safety sensitive position? So that's where it gets to be a very difficult analysis. Okay. So then it immediately morphs into the question of drug testing under Connecticut law. All right, so this is this right here that we're looking at. We're not talking about pre-employment testing. Pre-employment testing, we might get there, but under Connecticut law, pre-employment testing is allowed. Here, we're talking about post-employment drug testing. So first, know that Connecticut regulates only urinalysis drug testing. So you could have another type of drug testing. Urinalysis, I think, is deemed to be the most reliable, but some people do hair drug testing, hair follicle drug testing. And, that's not governed. So you could say random hair follicle testing is allowed under Connecticut law, but then the question becomes, well, how reliable is that? So that's why everybody goes to the urinalysis. So under Connecticut law, random urinalysis testing is not allowed. You have to have reasonable suspicion, and the standard for reasonable suspicion is extremely high, and it has to be put on the employer. And you should know that, again, if we're not in a DOT type regulated scenario, if you have a driver who gets into an accident, not DOT regulated, an accident itself does not constitute reasonable suspicion. So you can't have a policy of post-accident drug testing unless, well, you can't have it because it's random testing that is allowed. Now, can a person sign an opt-out for and sign ahead of time an acknowledgement and waiver that they agree to undergo drug testing? That may be possible. And so if you have that situation and you want to enter into some kind of agreement with employees in a certain kind of job, that they would be subject to post-accident drug testing and that they agree to that ahead of time, there would be a way to do that. And, we could walk you through that. But random testing in Connecticut is okay for safety sensitive positions, but you have to have the position designated as safety sensitive by the labor commissioner. So the Department of Labor does maintain on its website a list of safety sensitive positions. It doesn't matter if those are positions you already have and they've already been approved. You still have to get your specific job approved by the Department of Labor. And again, we could help you with that if you wanted to walk through it. Certain industries, and if you're in those industries, you would know, already allow for random testing, such as transportation, student transportation or school bus, and teachers aid, other roles where they're exempted out from the law prohibiting random testing. Okay, so an employee's eligibility for promotion, additional compensation, transfer, termination, disciplinary, or other adverse personnel action solely on the basis of a positive urinalysis test. An employee's eligibility can't, so I'm not, where's this going?
Yeah, this is, I know, there's a mistake
We're
here.
missing something
We're
here.
missing something there. There's a mistake, but no, basically it's saying you can't consider drug testing in connection with any of these things, any of these promotion, additional compensation, and other personnel actions, unless there's an initial positive urinalysis test that is subsequently confirmed by a second one. Okay, utilizing now we're getting very technical. Utilizing I said grass. I'm feeling Beavis. Utilizing a gas chromatography and mass spect. You knew what was being said. You just didn't want to pronounce those words.
I threw it over to you.
And spectrometry
Exactly.
methodology, which has been determined by the Commissioner of Public Health to be, as reliable or even more reliable.
So you know what? To sum this up, I think everyone here who's doing any drug testing does it with an outside agency,
Yeah, right.
and they know how to do it. That's, that's
Right,
what this is.
right.
They know how to do the drug testing. Okay. So, prospective employees, if you're testing prospective employees, they can be tested, but they have to be informed in writing of the employer's intent to conduct a test. The test has to comply with the testing requirements, which we just went over, and surely your drug testing organization would do that. And they receive a copy of any positive test results, and the results of such tests shall be confidential, not disclosed by the employer or its employees to any person other than such employee to whom such disclosure is necessary. So here's the big thing here, as all of you who do pre-employment drug testing know, that the drug testing organization is not going to disclose a prescribed medication, right? So they test out as negative. That's usually, you don't even know if they're on anything, unless, again, there's some specific reason why you need to know, like DOT regs or something. But for general run-of-the-mill drug testing, if a person has a prescription, my understanding is that the drug testing organization will not test them as positive for that because they have a legitimate prescription. Now, what's the exception? Medical marijuana. Why? Because it's a Schedule I drug. And so a lot of these drug testing organizations, in my experience, they will inform the employer because they want to put that whole liability, risk assessment, interactive process, whatever, on the employer, even in states where medical marijuana is prescribed. So this is where the employer gets into the position, which it otherwise wouldn't get into, of knowing what medication an employee is on. And then it's on the employer to have to try to deal with it. Observation is prohibited. Employers cannot watch. Results are maintained with employee medical records subject to privacy protections inadmissible in criminal proceedings. Reasonable suspicion. So I advise against drug testing on the basis of reasonable suspicion unless the person is so clearly impaired that anybody would think they were impaired. The problem with this is there are a lot of reasons why somebody may appear impaired, but if they do appear impaired and you can articulate, it's an articulable standard. They couldn't stand up straight. They had alcohol on their breath. Their eyes were dilated,
They looked a little funny, isn't it?
They looked a little funny. They seemed a little off, not sufficient.
Right.
So if you're going to do reasonable suspicion drug test, the employer may not require a urinalysis test unless the employer has reasonable suspicion that the employee is under the influence of drugs or alcohol, which adversely affects or could adversely affect such employee's job performance. Tests without reasonable suspicion are permitted where authorized by federal law. We've talked about that. High risk or safety sensitive occupation as defined by the Labor Commissioner in Connecticut. Again, that would be random drug testing allowed if you've got your position deemed high risk, safety sensitive, or testing as part of the employer sponsored EAP, so, and voluntary, or is voluntary. So that's where the testing is voluntary. That's where I think that you can get the potential for a consent form from employees in certain positions to do drug testing. But if it's a safety sensitive position, the best thing for random drug testing is to get it certified by the state and then do the random drug testing again. Post-accident is not considered random, but you can get a consent form for post-accident testing, or you might be required to do post-accident testing if it's required by federal law for the position. Okay, so still Connecticut drug testing exceptions. Medical screenings with written consent of the employees to monitor exposure to toxic or other unhealthy substances in the workplace or in the performance of their job duties. Let's see. Employers can prohibit the use of intoxicating substances during work hours or restrict an employer's ability to discipline an employee for being under the influence of intoxicating substances during work hours. Okay, so a drug testing program under the Department of Consumer Protection for certain kinds of organizations. I mean, this is certain kinds of jobs. It's really probably not going to apply to anybody here. The second one, let's see, I just want to make sure I understand what this is trying to say. Employer's prohibition of the use
Permit the employer to prohibit.
Right. Well, okay, so I mean, I'm not sure what the second bullet point is saying here, but I can tell you that you cannot do random testing except for under the conditions that we just discussed. So, and if people are working in a potentially toxic work environment and they are required to undergo medical screenings, then if there's a written consent, yes, they can do that as well. Okay. So there are damages that an employee can pursue. There is a private right of action against the employer, the lab, a medical facility, if this is done incorrectly. Anybody who has a CBA, you know, the CBA cannot change this law.
All right, now we'll switch over to New York. New York offers medical marijuana registration cards to certified patients that have a serious serious condition that's been defined as, you know, cancer, HIV infection, or AIDS, ALS, but similar to the list we saw for Connecticut. And in fact, it also includes post-traumatic stress disorder, and it appears to be the only mental health condition that's on the list. In addition to that, it's approved for opioid replacement therapy and opioid use. PTSD was actually just recently, it wasn't even in the statute, it was recently added by the New York State Health Commissioner as a qualifying condition. In New York, you cannot smoke marijuana. You cannot smoke medical marijuana. It is not permitted, okay? I'll tell you what though, if you walk down the streets in New York City, you will think that not only is smoking medical marijuana acceptable, but you would think that recreational marijuana is also legal. It's literally all over the place at this point. But it needs to be kept in its original packaging, except for the portion that's being consumed, okay? It can't be, again, smoked, consumed, vaporized, or grown in a public place. So again, similar to some of the other states, similar to Connecticut, employers can require that employees not be impaired by a controlled substance when performing work duties, okay? Now, New York, unlike the federal law, recognizes certified patients as having a disability under the New York Human Rights Law. Therefore, you can't terminate or refuse to employ someone based on their status as a medical marijuana patient. So here we're not looking at the underlying disability that entitles the employee to be a certified medical marijuana user. You actually look at their status as a medical marijuana user and assume that it was prescribed properly, okay? Employers must reasonably accommodate medical marijuana patients, except they can't prohibit them from being under the influence at work. And employers are not required to take any action that would violate an express federal law or cause the loss of a federal contract or funding. So unlike Connecticut law, we have a very short slide here on drug testing, because workplace testing for marijuana is not limited by New York State law, okay? New York State law does not have a drug testing law that applies in the workplace, okay? But employees can still challenge tests on other theories, including disability. Americans with Disabilities Act and medical marijuana users and testing under the ADA. Discrimination. Are we disproportionately testing a protected class of employees? Are we focusing more on men? Are we focusing more on women? There are limitations, but not necessarily based on a specific drug testing law. Then there's also privacy or defamation possibilities that an employee can object to having been forced to take a urinalysis test in public, although I don't see that as very probable, or publicizing false positive results. So that's New York State. We're going to go to New York City in a few minutes, but for now, let's talk about Massachusetts. Massachusetts enacted legalized recreational marijuana in late 2018. As of last month, there are 33 dispensaries statewide in Massachusetts. Massachusetts also offers medical marijuana registration cards for patients with debilitating medical conditions. Again, employers are not required to accommodate any on-site medical marijuana use at any place of employment. Unlike Connecticut and New York, there is no right of action for employees subject to an adverse employment action related to the use of medical marijuana, meaning the law is not necessarily clear whether they can sue for adverse actions relating to their use of medical marijuana, okay? Employers can still be fired for failing a drug test. A current bill before the Massachusetts State Senate would offer greater workplace protection to recreational users if it's passed. It currently provides that an employee cannot be discriminated against or otherwise penalized for using marijuana as long as the use of the marijuana is not in the workplace during work hours or in connection with performing tasks of employment, and the employee isn't impaired due to the consumption of marijuana in the workplace or while performing job-related tasks. So let's talk about drug testing. Webster versus Motorola, a Massachusetts case from 1994, recognized that requiring an employee to submit to urinalysis involves an invasion of privacy, because in case you did not know, the act of urination is inherently private. The court actually said that.
It takes a court to tell us that.
I'm so happy that there are opinions like this, because sometimes I can't figure it out for myself.
Gosh.
An employer may have a substantial and valid interest in aspects of an employee's health that could affect the employee's ability to perform job duties. Whether or not random employee drug testing is valid has to be weighed on a case-by-case basis. There really is no separate state statutory scheme or state law that governs workplace testing, okay? And finally, we get to New York City. The reason we raise New York City is that it has a very interesting statute that is going to be enacted, well, which has been enacted, but won't be enforced until May 2020. Pre-employment marijuana testing will be banned, okay? You will not be able to to test for marijuana, conduct pre-employment marijuana testing beginning in May 2020, except for law enforcement jobs, certain construction jobs, jobs requiring a CDL license, that's a commercial driver's license, basically safety-related positions. Jobs involving the Federal Department of Transportation regulations that require drug testing, federal contracts or grants that require drug testing. So it's interesting because New York hasn't legalized recreational marijuana, okay? So certainly New York City hasn't, although you think that they had, but they have not. Yet, they've decided to sort of shelve the whole idea of discussing whether or not it's legal by just banning pre-employment testing. So this is something that I think is likely to happen in other states as a result of maybe some hesitancy to permit recreational marijuana. So here are some basic best practices for human resources. Don't tolerate marijuana use on the job. Nothing requires you to do that. Learn to figure out how someone looks when they're impaired, or train managers to spot signs of impairment. Don't ever inform managers of an employee's medical marijuana status unless it's necessary for the job, okay? Talk to a lawyer about relevant state laws before setting policies and testing rules, because clearly if an employer has employees in different states, testing policies and state laws are somewhat different, and they're going to need to be complied with, even if your headquarters is in a state where you're in complete compliance with the law. So educate employees about the company marijuana use policy if you have one, and the repercussions for failed tests, okay, and post-accident or reasonable suspicions tests. And I believe that is it for us.
Great.
That's
We
it.
managed to finish on time.
All right.
Great.
Well, we thank you very much for spending your Friday with us, and we hope everyone has a great weekend.
We'll keep an eye out for the PowerPoint, and if you have any additional questions, as I said, feel free to email Sal or me or give us a call, and wishing you all a very happy and healthy holiday season.